and, and John McCord, who is his deputy and is a senior lecturer. The centre launched last year and is already doing some very, very interesting work. So we thought it would be really interesting to invite them to come along and give us an update on the projects that they're involved in. They're going to talk for about half an hour, 35 minutes, and then that will leave us with time for questions and comments. So without further ado, John, thanks very much for sharing your time with us, and over to you.
Thank you, Andy, and thank you everybody for having us along today. So as Andy said, our centre is about a year old, and we are involved in looking at the intersection of law and technology. But we thought today we could start talking about a little bit of the research that we've been leading here on AI for judges, for the judiciary. So the purpose of our research was to examine in what ways can we support our judiciary in the judicial decision-making process, whilst also at the same time preserving their role as an ultimate decision maker. So of course we can get all the great benefits of using AI, and I don't think that we need to set that potential is out. But if we could tap into that for judicial work, then on the other hand, we need to be able to do so in a way that mitigates systemic risk with the foundational principles and 5 constitutional dimensions, which we'll come to in a little moment, that's framed around the mechanisms for doing so, such as ensuring fairness, ensuring transparency, legality, and institutional trust. So our project, named Hercules, is an agentic AI in judicial decision making. It's a project that is exploratory in nature and is a tool that's going to be demoed here today. It's the first of its kind globally that we're aware of, and we'll come to that now just in a couple of minutes. If I can get the slides to move on. So, no. Just bear with me, please. What she did there, but it's moved. Very good. So the technical development, then we designed and built the agentic AI proof of concept, which we named Hercules. It combines chunking-based legal retrieval, land graph orchestration, and blockchain-enabled audit via a hyperledger fabric. I will say this: we have 2 lawyers here in the room that are talking, so we're not technical experts. We work with an interdisciplinary team, but we're told that this is what we have adopted. So then to the empirical evaluation, we want to test Hercules against real-world case scenarios, gathering rare empirical evidence from the UK judiciary on acceptable AI functionality, goal, alignment, and assurance. And then to governance and safety. This funding was supported by the AI Security Institute in London. And obviously, safety and security are at the core of all the research that they want done. And it was at the core of what we developed out. So we identified under governance constitutional dimensions to be able to produce principles, produce guidelines, and also a practice direction style governance for AI in our courts, tribunals. So the question then is, well, so what? Why does that matter? Well, it's the systemic risks that arise around AI injustice in this high stakes arena. We have to watch for various different elements. So one area is the loss of human oversight. That's a concern. Loss of judicial independence is another concern. Is it something that the algorithms could start to influence the human judge? We looked at the concerns around erosions of public trust. So if we build these, if we start using this type of technology, with our judiciary, is that something that the public is willing to accept? And if it is, at what level? Is it a small claims dispute level? What about if somebody's having visitation rights decided for their access to their children? Or what about the repossession of a property? Something like that. Is that something that the public would have trust in? Then lack of accountability is an important one too. So who bears responsibility for any errors or unjust outcomes? Does the technology bear any of that responsibility or accountability? And then, of course, unreliable outputs from the AI. We know that AI at the moment hallucinates by producing legally incorrect outputs. It can make up case law. It can and provide false citations. And in a judicial context, then those errors may be invisible to the judge and impossible to detect unless we have built in robust verification. So, first of all, the non-negotiable. We need to build this with meaningful human in the loop as a structure. So, yes, it's agentic, yes, it's very capable, but it's very important that the human, the judge in this case, is meaningfully involved in the loop. Transparency, so any of the reasoning that it produces must be explainable at every step. It has to be clear how it got to the draft decision, just like a human judge explains she or he is going to decide a case and how they got there. Governance, so safety and insurance precede deployment. And also it's a constrained system design with bounded functionality with escalation paths built within it. I spoke a little earlier just about the 5 constitutional dimensions of AI and judicial decision making, and we've set those out here in our slides. So procedural integrity, so a fair hearing and a complete record that can be examined. Professional responsibility, so accountability of the legal actors that are involved with this court process and using technology within it. Epistemic reliability, so quality and governance of AI outputs. Judicial independence, the human judge is always the final decision maker, it's the ultimate decision maker. And then finally, the rule of law legitimacy, so constitutional and democratic compliance being really quite key. I think maybe John, you'd like to speak to that one.
Yeah, certainly. So as John said, we try to stay in our lane, but in relation to the Hercules architecture, it's a proof of concept prototype, and really we designed it in a way to preserve judicial autonomy, but also designed to allow judges to cut through large amounts of complex legal materials and to ensure that those materials are searchable and structured and usable in relation to what they're trying to do with the case and what their particular action might be in a particular hearing mode, whether it's in a trial, whether it's in an appeal. So as John has mentioned, we adopted a chunking process where we have sort of dissected cases into an 8-chunk representation. And that's to try and preserve distinct legal dimensions. And in other words, we're trying to make sure that similarity retrieval is based upon reasoning, facts, procedure, citations, etc. So they're all correct. In doing so, the team has built this out so that it's a hybrid retrieval method which combines both semantic understanding with precise legal term matching. And the idea behind that was to try and capture both conceptual similarity but also doctrinal specificity in relation to any the RAG model. We also built this, as John's mentioned, around this governance structure with transparency really at its core. So the whole idea was to return a match in relation to the system, but it matches the correct dimension and allows the correct part of the case to be doing the work. And we'll see how that sort of plays out later on when we show the demonstration. So on top of that, the team also have built in a metadata enhancement layer, which helps the structure of the material, and it includes features such as classification, precedent strength, complexity, and ultimately confidence signals in relation to the retrieval. The chunking, I mean, this is well-trodden ground really, but the reason for that is to make sure the cases and the retrieval isn't based around one block of text which might not be correct for what the judge is trying to do and what the case papers might actually need.
So we're now going to go to a live demonstration. Sorry, not a live demonstration, a recorded demonstration is what that should say, because we don't trust technology to work when it's meant to work. But hopefully you'll enjoy just John's narration as he takes you through the Hercules. And hopefully you can hear it.
It's a type AI judicial decision support system developed for the UK judiciary in their decision making while safeguarding core judicial values. The design principle behind Hercules is human in the loop, maintaining judicial primacy. Hercules structures case materials, serves as potentially relevant authorities, and assists with drafting, but it does not decide the case. The judge remains the decision maker at all times. Today, we will show Hercules in action on a simple matter, the case of Metropolitan Crockery Holdings Limited versus Artisan Coffee Company Limited. You will see how it structures the record, serves as potentially relevant authorities, and turns that structure into an editable draft for the judge. Hercules works through a simple four-stage pipeline. First, a knowledge base, which have historical cases which supports grounded retrieval. Second, we load skeleton arguments so the system captures the parties' positions and legal pleadings. Third, the platform runs a similar case search.
John.
Case. The judge remains the decision maker at all times. Today, we will show Hercules in action on a simple matter, the case of Metropolitan Crockery Holdings Limited versus Artisan Coffee Company Limited. You will see how it structures the record, serves as potentially relevant authorities, and turns that structure into an editable draft for the judge. Hercules works through a simple four-stage pipeline. First, a knowledge base, which have historical cases which supports grounded retrieval. Second, we load skeleton arguments so the system captures the parties' positions and legal pleadings. Third, the platform runs a similar case search using semantic matching. And fourth, it produces an AI-assisted draft judgment that the judge can edit and finalise. The structure is designed to make the system's contribution visible, bounded, reviewable, and transparent at every stage. Step 2 of the pipeline is where we bring in the parties' positions. In this case here, the skeleton arguments. Hercules treats those submissions as distinct inputs: claimant, applicant on one side, and the defendant, respondent, on the other. This separation matters because it preserves the adversarial structure while still letting the judge see the case as a whole. Think of this as a disciplined intake before the system does anything else. Now we move to similar case search. Hercules returns a ranked list of candidate precedents, each with a similarity score. However, the score is not the point. The point is the explanation. Why has this case been suggested? For each candidate, you can see the matching sections, such as case analysis and legal reasoning, along with keywords and legal issues driving the match. And within this, you can open the excerpt straight away. We can see this in example in relation to the legal reasoning of this case. We can identify the excerpt and allow our judicial officer to read this. So this means that this is something that the judge can inspect, and it's not necessarily something that they have to accept. This is ultimately to ensure that there's no over-reliance and that the judge retains full control of the system at all times. Once the judge is satisfied, the judge can continue the judgment. When we move to the judicial area, we can see that the system has retrieved findings and facts, and it displays this through a chronology, agreed facts, and contested facts within the system. The judge can click, for example, on the contested facts and the system will identify the competing versions of the claimant and the defendant. It will offer a judicial finding, offer a credibility assessment, and importantly, it will completely trace and logic trace all issues to the relevant papers in the case. This can be filtered by background, procedural events, disputed facts, depending on what the judge wishes to consider at that moment in time. This is designed to assist the judiciary in cutting through large amounts of data accurately and quickly. In doing so, the system offers support in relation to findings of fact, provides confidence levels and assessments of the parties' positions, and will also identify the basis upon which that assessment has been made, including the key evidence within the case to support that assessment. From there, we move to issues and positions. Here, Hercules identifies the issues for determination, in this case, 2 liability issues. And it maps the parties' positions in a structured way to allow arguments supporting and arguments against, so the judge can quickly test whether any material has been missed or indeed oversimplified. So if we open one issue, you can see the layout, the parties' positions, the analysis, a provisional determination with an explicit confidence indicator. More importantly, the determination links to the supporting facts in the case, the applicable law. That's the architecture doing its job, trying to ensure that every conclusion is appropriately tied to the relevant outputs that the judge can. Bottom, there's a preview of how this would appear in the judgment so that the judge can see the draft structure before deciding what to keep, revise, or indeed reject. Now to relevant law. Hercules builds a framework issue by issue. It offers a proposed legal test, the statutory basis, and a set of authorities marked by status, including binding sources. Know that the relevant statutory provisions are pulled through with short notes explaining why they matter to the case. Again, the intention is not to replace legal reasoning, but to make the route to the sources fast, reviewable, and transparent for the judge. Finally, in our drafting workspace, Hercules brings everything together. The system generates a draft judgment document with the case header and structured sections in the judgment. The judge can review the draft, switch to edit mode, notes, and save, accept, or proceed through the workflow. This is the handover point where Hercules offers a structured starting draft. The judicial function remains entirely in the judge's hands in relation to their editing, rewriting, and final approval of a draft. Once the judge is content, they can confirm they have reviewed the draft, verified all facts, relevant law, and indeed decisions and orders, and they can approve and seal the order. The system will also record if the source is referenced within the draft decision. As a governance layer, Hercules also includes a registry and full audit log. This creates an activity trail, uploads, searches, draft generation, and links all these matters so that they are fully transparent and reviewable. The aim is to make the AI assistance inspectable rather than indivisible to someone who may want to review it. So to summarize, Hercules offers a structured case record, maps parties' position, supports explainable precedent search, links determinations to supporting facts and law, produces an editable draft while keeping judicial primacy and transparency at the centre of the system.
Okay, so let's see, can we move on? Andy, could I just confirm with you that you're seeing the right slides?
I'm seeing empirical evidence and critical safety finding.
Very good. Okay, great stuff. So, my speaking.
So you've seen Hercules and what we tried to do, and we've mentioned the name Hercules a number of times. So I suppose we should explain where the name came from. So Hercules is a reference to Richard Dworkin's Law's Empire, where he hypothesized, theorized actually more accurately, about a superhuman judge that knew all the law, and of course he called it Hercules. So we thought it was a bit of a legal joke that we would use that name. So you've just seen the Hercules system, and one of the important things that we tried to do, not just with trying to co-design and build out a system for judges, but it's also to obtain empirical evidence and findings in relation to judicial use of such a system. A broad brush sort of evaluation evidence has, particularly with the system and its use on real live cases. So we used a test case from Court of Appeal where we took real live skeleton arguments, real live oral submissions, and we brought them into the system to start our evaluation, basically. And the system worked very, very well, actually very good with the case retrieval. It retrieved what we expected it to retrieve, and indeed it actually retrieved the correct cases that the court used in its judgment. And it also brought in some of the cases the parties had used within their skeleton organs. So there's a really interesting findings that we're going to be reporting on relating to that. But the headline figure is strong case retrieval. We also were able to test it against, as we said, some real cases, and it got the correct outcome determination in many of those cases. Now, not necessarily for the exact same reasoning, but of course, if you're on an appeal bench, a panel of judges might come to the same conclusion, but for different reasons. But it is something that we're looking at in more detail. And ultimately, that leads us to the bottom point that we've mentioned here in relation to reasoning. Reasoning does need further work. It is an area that we need to look at more deeply, of course, and that we hope to be doing that as we move this forward.
Yeah, and we have already taken some soundings, obviously, from judiciary. We recently were over in London with some senior judges locally here as well through the Lady Chief's office. What we have put together a pack that we're going to be putting out hopefully in the next few days, which should gather much broader feedback and evidence from judges as to what they're actually happy with, because where we're going next in this presentation is what you've seen is Hercules, and it's actually Hercules 1. The first attempt at it. When we got into this, we realized, well, we ran out of time. It was only a 12-month project. We started to run out of time with the developers to get what we want built. But we have wireframing up what full functionality of what we think it should be able to do, and we're going to come to that in a minute, sir.
And yeah, just, I mean, on the right-hand side, where the point we would make is that any system's as good as the data that it relies upon, and that for initial work in this area, we have a number of key things that we would say around the system architecture design. How knowledge bases should be created, and in fact, what should actually be within those knowledge bases. And it was really interesting to hear from the judges their views on that.
Yeah, good. Well, so to the key findings then. There obviously we had one eye to assisting ASI in this space around security and safety and making sure that everything was transparent. And so that plays out then in some of the objectives in our key findings. So we delivered our proof of concept, and the hope is that we can take that then to an MVP standard where it's been thoroughly bench tested, and then into a pilot with the judiciary. And we're currently trying to secure additional funding to allow us to do that. The safety architecture, we sort of talked a little bit about this. So it is a constrained design. There's meaningful human in the loop. There is a blockchain audit trail, which John sort of showed you towards the end of the demonstration, where there's full traceability, and it's fully explainable. The empirical evidence that is quite rare. There are one or two that have managed to get before our judges and ask some questions. But we are enjoying great support from our judiciary in London and further afield and at home here in Northern Ireland. So we are gathering that rare direct insight from UK judges on what is acceptable. So it's quite interesting. When we were in London, we had obviously a number of judges, quite senior judges in the room, and they couldn't agree between them as to what it should or shouldn't do. So, for example, should a judge see a draft decision or not see a draft decision? Should they be drafting their own decision and then they can compare and contrast with what the AI provides it? Why is that an issue? Well, because it could start to influence the judge. Maybe the judge isn't really thinking in their you know, on their own. They're not. They're receiving this sort of influence from outside, which isn't ideal. So it's quite interesting. Where we need more of that type of feedback, and we're trying to gather that to see when we come to Hercules 2 in a moment as to what this functionality the judges actually want, so that it's the design is led by the people that are going to be using it on a day-to-day basis. Do you want to speak to a couple of those?
Yeah, listen, I mean, we've sort of broadly covered the governance point, but I think that the key thing that the findings and project are showing is around the dimensions for how we should analyse AI, but that's have constitutional conversation about this, and we'll talk about this later on as well.
Yeah, and then so data. Data is a huge problem for anybody doing research in this space. It's the same with health, the same with other areas. The data is king. If you get access to data, you're away. Data in the UK is complicated to get a hold of. We would need that for MVP as part of the testing that would need to be done. And we have had early discussions with the MOJ in London as to whether that's a possibility or not. The research engagement, well, I suppose it's quite novel research, so everybody's been very kind and given us plenty of space and time to talk about what we're doing. We've been all over Europe and also into New York and Boston. We presented at Harvard while we were over there in the autumn. So yeah, it's quite well received today. So I've already sort of talked to this point is we want to look at trying to get this now into a minimum viable product. Thorough bench testing, formal verification, and then infrastructure investment, being able to get it out into a pilot. We have been doing a bit of work along that's sort of already come out of the 12-month period, looking at AI assurance and that challenge, and that seems to be something that very much everybody's starting to talk about. With paper out on zero knowledge proofs already, looking at the possibility of what it could do in relation to making sure that bias, etc., doesn't enter the arena when it comes to decisions. And that sort of cryptographic verification plays hand in hand with that. And one of our colleagues, the associate director of the centre, is a blockchain specialist working out of our McGee campus, Vimal Tuivedi. So yeah, there's quite a bit of work going on in the background on that as well.
Yeah, so John has mentioned Hercules 2, and what you see on the slide is our sort of wireframe coded Hercules 2, and you'll see that within that, I don't know if that's moving, John, with
just tap it again.
Tap.
So look. See if we move into present view, probably will do it, but I don't know what that's going to do. Let's have a little look.
Yeah, that's better. Yeah, so you'll see that we have a model screen. We're not going to show a demo at this point, but you can see the concept uses this sort of structured autonomous checks throughout the system. So on the screen, you'll see an example of a system. You'll see that we are able then to toggle into the system settings. And some of the things that we have been considering here is, for example, the difference between trial mode in relation to decision making and also then appeal mode. So in appeal mode, of course, the system would focus more on appeal principles and the relevant and applicable law in relation to an appeal as opposed to hearing evidence at first instance. And you'll also see that we have judicial personas. So of course, it's entirely possible to have a decision which is sort of strict. And a decision, we can have that which is more purposive in its approach. We can also build in personas where the system can actually mimic a judge's own writing style, and can also the judge can download their thoughts and their experience into the system as well.
Yeah, and where this actually came, so full disclosure, we met with a very preeminent professor at MIT when we were up in Boston, Sandy Pentland. I thought he was just being very nice to us and just taking the meeting, to be honest. But he had actually read what we'd sent across and was quite interested in it. And he started to play with this idea of, well, with the judges tend to work in silos, and it's not very nice, it's not collegiate. Sometimes they might like to know what the judge down the corridor thinks. And then we got sort of playing around with that idea and said, well, you know, in America, what about the persona of Ginsburg? Or what about the persona of Lord Denning, if you're a Lord Denning fan in England and Wales? So that started to make us think about the persona, and then also we've talked about that out with some judges here, and I don't think they're going to be using Lord Denning as a time soon. But I think what John's talking about is quite interesting in that if you have a long-standing time on the bench with a lot of judgments, in actual fact, the stylistic approach that you take as a judge initially play out here through a judicial persona.
And again, in the sort of main judicial area, you can see that we've fleshed out more of the features and functionality, and that really sort of orientates around different things that we've been considering. For example, we have our audit ledger, which we discussed before, but we also think that it's really good functional piece for a judge, not just in relation to decision making at the end of a case, but also what about all the reviews, first instance reviews leading up, and specifically around procedure. So how does that interact with legal rules and legal procedure, for example, the civil procedure rules in England and Wales? So it's very possible to consider and to implement these sort of features.
I think you just passed over one there, John. I think one of the important points again is just this, is to be able to show this reasoning. So those of you that are in the audience that are familiar with the issue around black box, it's trying to deal with that. It's trying to show how the reasoning got to the final decision. That's why we accept human judgments, is because the judge takes the time to explain to us how they got there. And if we don't like it, or our lawyers that are representing us don't like it and think it's wrong, then that forms the basis for an appeal to a higher court. So it's sort of inherent within our judicial systems that we get an explanation. And certainly if AI is going to be used in any meaningful way around drafting and decision making, etc., it needs to be able to be verifiable and transparent.
John had mentioned earlier as well about the hallucination problem. Well, again, it's something that we in our second system started to play with. We've built in a hallucination checker and through integrity alerts for the judicial officers. So in the example that you'll see, this is where the system has ingestion of papers. The system's pulled out these integrity flags. And within that, then the judge still retains that the ability then to scrutinise, examine. They could, if the full functionality was on at the present, they would be able to go in and see the decision. They can verify it against a corpus that is of the system, the system's body of law, and they can also elect if they want, for example, to desist or mark as approved. So if the judge was to say, well, actually, I know this decision, this is correct, they could approve it, and then the system would then bring that back in to its draft decision in relation to the reasoning of the case, the applicability. And we mentioned, and it showed you some boxes around procedural checker. There was also a human rights checker, so we're very, very interested as well in fair trial assessment. But I think the key point here is this allows the judge at any time when in hearing mode or in appeal mode to actually get an in situ assessment of Article 6 against a corpus of Article 6 case law. And that's really important for a number of different reasons, but the primary reason is the parties don't have to wait to remedy or cure a potential human right breach. The judge can actually keep this in scope, in vogue, essentially. And the idea is to try and to prevent that from happening.
I suppose to just for a moment talking about Article 6. So I remember one of our Chancery judges coming in when I was training at the bar, and came in, this judge pulling their hair out with a litigant person who themselves was making a fair fist of it. But the difficulty, when I talked to the judge afterwards, he said that this is increasing, and that was nearly 15 years ago. So you've got a massive amount of litigants now, or pro se litigants. It is an issue for the judge. Judge needs to make sure that if they've got a litigant person in front of them, that they are compliant with their Article 6 rights. So does the litigant person actually understand the processes? Has that all been explained properly? So there's more to do in this. As John has said, it is something we're alive to. And how deep we can go into it, I'm not sure, but it is something that we are very interested from both sides of the coin. Also interested from litigants in person, and that's another piece of research that we think needs also done. But yeah, just
yeah, no, I mean that's absolutely correct. And some of the early signals that we're getting from our judiciary is they actually welcome this. They think that this is quite a good thing that could be embedded within. And we also see that we do also have a complete chat within, and the judge can interrogate any of the papers or any of the issues at any time through speech as well.
Yeah.
But ultimately, it's the ideas around trying to give the judge real-time ability for compliance, querying, editing, drafting, redrafting.
Do you see, as we're going through this, we're trying to, I talk about it like being a cockpit for judges. So if you can imagine, well, I'm not a pilot, but when I look into a cockpit, I'm impressed at how everything's just set out and laid out for the pilot. And it's all at the touch of a button, to use that phrase. And so we want to develop this in the same way for judges, so that the technology, not only is it secure and safe, but its functionality does everything that they require. So what have we been learning from the judicial perspective? The early signs are that this would be useful support for them. This is something that would be helpful. Obviously, it comes with red lines. We've listed some of these. So the evaluative judgment, credibility assessment, normative reasoning, and responsibility for reason. So responsibility is always going to reside with the judge, that is the ultimate decision maker, even through the use of the technology. There's also institutional trust. Now, that comes from a whole lot of different ways. So anybody interacting with the court has to trust the system. So that's right down from the judiciary, the lawyers that are engaging with it, and their clients, litigants in person as another group, and interest groups. They all need to have confidence in this, and that it's safe and secure for it to be used. The public have to have trust. Ultimately, this is one of the pillars of society and democracy. So it has to have trust. So that judicial control, that meaningful human in the loop approach is really important. The transparency is really important. And the fact that there's an audit trail at any point, it can be interrogated to make sure it hasn't gone off beam. All very important in relation to trust. Flag their unsafe use, so trying to avoid autonomous adjudication. Don't think society would be ready for that. Don't think the technology is ready for that just yet. We want to avoid opaque influence. We want to watch for model drift and make sure that that doesn't happen. And we want to avoid unverified legal output.
So a further dimension of the work, it's, John Austin describes this as playing chess, where you expose your pawn, who's initially, one front to fight on, but as you move forward and work through these, you then have a number of different sizes, different exposures. So we are seeing this as we go through, and one of the key things is we sort of had to get to grips with as well is, well, what's the constitutional issues, but also what are the potential legal barriers as well. So there is a number of things that we see around the disclosure, and candor in relation to duties in relation to AI and decision making. We're seeing that play out in case law, actually, in the United Kingdom at present as well. We've mentioned about our failure modes and the false citations and the distorted facts, ultimately, which are fake text, essentially. Where does the human responsibility lie in relation to that verification and supervision of the system and its use, and also how we should respond procedurally? And this is actually layered around governance. For example, the UK's response, we've actually mentioned before about practice direction, about shortly. Parliaments are being very, very slow, but I think that eventually they will have to go to an act of Parliament in relation to AI and its implementation within our court.
I think that's an interesting point. So we had a bit of a chat here locally on this. What's the benefit of a practice direction? Well, everybody is working to the same standard. At the moment, the Bar Council here haven't come out with AI guidance. The courts haven't either. The Law Society about a week ago, 10 days ago, released their guidance. The difficulty with that is while there's probably plenty of crossover, in theory you could have 3 groups within the court system all working to different standards and codes of conduct in relation to the use of AI, which, while a code of conduct would be useful, I think for the benefit of the courts and for everybody to be working to the same standard, a practice direction really needs to be looked at. And I know UK, England and Wales don't have one yet, but I am led to believe that that's well on its way. And there has been guidance given, several editions of it at court level in use of AI.
Yeah, and they're obviously consulting at present as well in relation to taking these matters forward. And John, and why that's really important, John's already mentioned it, is around, for example, litigants in person, but also expert witnesses. Anyone who comes to court that may submit any papers or reports or pleadings, for example. So that's why we think that that's probably the right course, in our view, certainly, that needs to be charted. But mentioned about the constitutional conversation, we're writing up a paper on this at the minute, but it effectively crosses over with where we started this presentation, our 5 dimensions, but also linking in with those legal questions around GDPR and the EU AI Act and this governance. It's all bounded up in relation to the same sort of issues. But what we would be very clear about is that we actually need to have this constitutional conversation in relation to AI risk.
Yeah. So you probably, the lawyers amongst us here have probably been following some interest how the courts treat submissions, undeclared submissions of AI and hallucinations. But also, there's been a bit of a discussion more recently around privilege, and it's interesting. So we had one of the first cases that out of the blocks was the United States and Heppner in New York, one of their regional courts in New York, and there Judge Radkoff took a very sort of hard view. And now, It seems to be a completely different decision in Warner and Gilbarco. But when you dig into it a little bit, if those that are familiar with it, in Warner, it's a litigant in person or a pro se litigant. And in those circumstances, they were using the AI as a tool to develop their own case so as to be presented. And the judge felt that that was protected and therefore would not be disclosed. Whereas in the United States in Hepner, the person that had used the AI, and it was an open source AI, was represented. So what the judge took the view there, well, no, you waived privilege when you shared this with somebody other than your lawyer. So it's kind of interesting. I'll give you just one. I don't have the citation to it, and it's anecdotal because somebody had asked for a bit of guidance from me, and that was in the courts about 2 or 3 weeks ago in Manchester in the commercial court. And there, somebody had secured very well this entrepreneur who represented himself. He was successful in getting an injunction in a commercial matter against 3 ultimately defendants. But there was a set-aside application made for 2 of those, and he threw the kitchen sink at it, unfortunately for him, via AI, a lot of it irrelevant, and didn't win on that front, and got hit with £155,000 worth of a legal bill on the other side because they were they argued that their time had been wasted with so much irrelevant material. So pretty harsh outcome. Reportedly, the judge threw the book at him, and a very costly exercise indeed. So I don't think it's completely settled, the whole privilege point. It's going to be interesting just to see how our own courts react to it. You highlighted, John, here the UK UT 81 IAC. Do you want to?
Yeah, well, there's actually a number of cases that are flowing from the court, but the upper tribunal have been very active in this area, and there was recently, as I said, two tribunal discussed about. In this case, was actually quite a junior, that was legal, and the upper tribunal took the view that putting any information in open source is effectively a breach, seen as a breach of privilege, and needed to be properly supervised by the governing lawyers on the team. There's one other thing that just comes to mind, and I'm going to bring back in the litigant in person point as well, and bring that in. I'm aware of, across the globe, different jurisdictions dealing with these matters differently, but just to build on the point that you'd made, in Canada, for example, a litigant in person was fined $5,000 because they cited hallucinated cases. We haven't confronted in this jurisdiction, but certainly in England and Wales, we see these cases every week actually being reported. So it definitely is a challenge, both in relation to behind the bricks and mortar of the court, also within firms, but then also in the more citizen-facing litigant in person debate.
Yeah. So I think we'll leave privilege at that, though some might have some questions afterwards. What's that? I think we've also covered most of this as well. So there is a little bit around experts and what the courts expect from experts in their use of AI. So again, a lot of documentation. There's the risk that people are going to turn to AI, and there's a risk to the calendar of the court and whether or not that's been declared. Again, this is why we come back to a practice direction. If a practice direction was put out in relation to this, it could cover all of these different elements and could then be updated as required as AI gets more prolific in its use and more powerful in what it can actually do. Okay, so be aware of the centre, follow us. We're on LinkedIn and other places, and we keep everybody informed as to probably too much about what